domestic migrant workers is a huge feature of the Chinese labor market in general. And any state-sponsored movement of a batch of Uyghur workers pursuant to a poverty alleviation initiative would presumptively be a basis for listing and a basis
Yep.
upon which an entity could no longer exist in a US bound supply chain. So it's going to be very interesting to see how other industries react and respond as the enforcement builds.
All right. The Uyghur Forced Labor Prevention Act, Congress's answer to human rights allegations in Xinjiang, is coming into effect June 21. To talk about the implications, today I have on the podcast John Foote, partner and head of the customs practice at Kelley Drye and Warren. John, welcome to China Talk.
Thanks, Jordan. Glad to be here with you.
The reason I'm particularly focused on the Uyghur Forced Labor Prevention Act is because when people talk about decoupling and what's driving it, and often you have, some folks looking at sort of import and export numbers and saying, look, they're kind of constant, like there hasn't been a big change. But my sort of conviction from the start of the Biden administration was that they were very interested and focused on taking the human rights dimension of this relationship more seriously. And it always sort of occurred to me that if decoupling, if like actual big numbers of trade related decoupling would happen, that it would happen in the context of human rights concerns. And as you alluded to, John, the idea of these forced labor transfers, where it's not just Xinjiang anymore, it's sort of folks being put on buses and sent to factories all over the country. Once you're sort of expanding the scope and the remit that the U.S. government is looking at to impact not just factories in Xinjiang, but potentially manufacturing locations all across the country, then you're looking at a potential where you end up potentially having this escalate towards numbers that do end up really impacting trade flows at a significant level. In that context of this relatively unsung bill and these, $25 billion of people in the Customs Department giving the Biden administration another flip to potentially switch and escalate and sort of raise some of these stakes and dial up some of the forces which are pushing towards a broader economic decoupling. That in particular will be really interesting to see.
I think that's a great point and very well said. And I agree. I mean, I think the reason that I bring this up as a point of contrast to the Section 301 tariffs is because that was sort of the most public and demonstrative that you could possibly be in initiating a trade war between two mega powers, right? I mean, the numbers were so large, and every press platform was covering this, breathlessly. Every single individual development. It is not difficult to imagine a scenario where every Chinese entity that is linked to one of these social programs of concern, or a significant percentage of them getting listed and it being massively disruptive to US bound supply chains. And that I think is why I consider this sort of a sleeper front in the US China trade war, is because if in fact you see hundreds and thousands of Chinese entities that are linkable to these issues end up getting listed and they are being hit, deeper in the supply chain, it could create massive headaches for companies that import goods from China to effectively replace individual entities at the time that they become listed. Huge commercial disruption, huge import disruption. And, yeah, you're right. This is getting covered, a couple of articles here and there. I'd say the importing community is pretty focused on this and pretty apprehensive about it. But in terms of the broader, focus on U.S. China issues, this is definitely an emphasized point of potential disruption.
So pre 2016, what did the US government do to stop forced labor goods from coming into the country?
Really, the U.S. Began enforcing what I would characterize as the modern era of forced labor enforcement as a trade matter in 2016. So the U.S. has had a ban on the importation of goods, any goods that were made wholly or in part with forced labor, since 1930, and there were predecessor provisions that went back into the 1890s. But for most of that history, there was what is characterized as a loophole in that ban. And the loophole said that if you imported something that was not made in sufficient quantities in the United States to satisfy the consumptive demand in the US, then the ban did not apply. So it was sort of an exception that swallowed the rule, because by definition, virtually everything that is imported because there is insufficient domestic production to satisfy demand within the United States. So the law did have very limited application and periods of enforcement. There were periods of enforcement in the 1980s, focused on Soviet Gulag system. There were periods of enforcement in the early 1990s, focused somewhat on Chinese prison labor. But really, since about 1994, there had been no enforcement of this forced labor import ban until 2016, when Congress removed the consumptive demand clause from the forced labor import ban. And since then, the U.S. has been the only jurisdiction in the world that enforces a prohibition on trade in slave-made goods made with forced labor.
So, John, let's do a little history detour for a second. Have you spent a lot of time reading what was going on in the 1890s and the FDR administration? Why did this become a thing in the first place?
Yeah, so it actually is. I actually have done a fair amount of historic research on this question, just because everyone wanted to know where this law came about, or how this law came about, what caused it. And the original industry that lobbied for a ban on goods made with forced labor were hat makers from Brooklyn, haberdashers. And they, I'm
Jesus.
not making this up. And they were lobbying because they were faced with competition from hats made in Eastern Europe in prisons, and they just couldn't compete on the prices. And apparently, there was also some prison making industries even in New York State at the time. And the legislative history, the congressional record actually has these exchanges where the lobbyists from this hat making industry came in and said, look, we got some relief on this issue in Albany, but we need help with regards to the hats that are coming in from Eastern Europe. And so a provision was introduced to ban the importation of goods made with forced or prison labor. And that was the genesis of the ban. So it was a commercial concern, rooted in the fact that it's difficult to compete when someone can produce a good without having to pay, fairly for the labor that is used to produce it.
There's a bit of like a Baptist and bootleggers dynamic to the initial passage, it seems.
Well, yeah, I mean, I guess I would say that it was definitely commercial and competition driven concerns. But certainly by the time that the Tariff Act of 1930 was passed, including this provision, which extended from just prison labor to include forced labor, it certainly was influenced by the labor rights movement, and the legislative changes that were precipitated from the labor rights movement in the 1930s as well. And it was certainly in the trade title and in the Tariff Act, unquestionably, but the inclusion of language about forced labor, including forced child labor, certainly has some lineage to the labor rights activists of that era.
So, who would have thought that the Smoot-Hawley Tariff Act, which everyone learned in their AP US class as like the thing that, Hoover thought was going to save the American economy, only to tank it and, kick off global, a global tariff war, in fact, is coming back into action in the late Obama administration. So maybe let's fast forward, 70, 80 plus years. John, what was the sort of discussion and dynamic that led to the reform of Section 307?
Yeah, so that's a great question, and I think that this would be worthy of someone sort of repiecing this together, and all the different legislative efforts that were afoot to try and remove this consumptive demand loophole. But the story, as I was told at one point in time, was that this was a cause of Bernie Sanders championing for a number of years, and that it was subsequently picked up by Senator Sherrod Brown, and eventually it was just slipped into an omnibus trade bill in 2016. the Trade Facilitation and Trade Enforcement Act of 2016, also known as TFTA. And the provision that in that bill simply removed the consumptive demand clause. It removed just, between two commas out of Section 307 and left behind a blanket ban on all goods produced wholly or in part with forced labor. And I think what's really significant about Section 307 is that phrase wholly or in part, because that little phrase, specifically the language or in part, serves to do something that essentially no other trade law does. And that is to bring the entirety of a supply chain, all of a supply chain, into scope and within the focus of a border enforced trade law. Historically, trade laws primarily focus on the actual finished goods that are being exchanged across that particular border. But by using this phrase wholly or in part, and in particular how customs has interpreted that phrase wholly or in part to mean any component of a finished good or any material that is used to produce a component within a finished good, going all the way back to ground, what this has done is it has served to make the entirety of a supply chain brought within the focus of the movement of a piece of finished merchandise across an international border. And that is completely novel in the context of global trade regulation. It just was not a part of the landscape before that. And so I think if you ask the drafters of TFTA and the folks who revised by removing that consumptive demand loophole, they would certainly say that it was, out of concern for labor rights, for human rights, for worker rights. But I think that a lot of folks were surprised by the scope and scale of the impact of simply removing this particular clause from the bill or from the law.
Yeah, shout out to the congressional staffer who pulled one over industry, perhaps, because and also gave John a lot more work to do, which is, I guess, is good and bad signs. But let's talk about the sort of 2016 to pre-UFLPA times. How did this this new regulatory tool end up starting to be applied in the China context in particular?
So Customs is the agency that is charged with enforcing laws, of course, at the border, including laws governing international trade. And Customs has within its regulations a very few sections that were dedicated to the forced labor import ban. So notwithstanding that it had not been enforced at all really since the mid 1990s, and only really sparingly prior to that, there was a regulatory mechanism in place. And the regulatory mechanism was actually crafted in the Kennedy administration and has never been updated since. And it was designed to function in such a way as to be able to target goods that were made by a particular producer, like a finished producer that was perhaps using forced or prison labor. And so this mechanism, what it does is it allows Customs to identify a class or kind of merchandise. And it really contemplates that the class or kind of merchandise is merchandise made by a particular type of producer. And then what Customs will do is it will issue an order on that class or kind of merchandise produced by, for example, a particular factory. And it will say this type of merchandise from this factory shall be detained at the border. And that issuance of that order is known as a withhold release order. It's actually a memo to the port directors from headquarters saying, you shall withhold release of this merchandise. It shall not be admitted into the United States unless the importer can prove that the goods were not made wholly or in part with forced labor. There's a very low threshold. Yeah, it's a difficult burden of proof. That's right. And correspondingly, it's a relatively low burden of proof for the imposition of one of these orders. So a withhold release order is also referred to as a WRO. And when Customs has issued WROs historically, particularly in the 2016 to early 2021 era, for the most part, it would issue WROs against individual manufacturers. XYZ company in China identified for producing, products A, B, and C with forced labor or with prison labor or something. And then those products by that producer would be detained at the border. And if you were importing goods from that producer, you would have the opportunity to try and prove that your goods were not made with forced labor and try and get customs to agree that your proof was sufficient and then allow the goods to be released. That is the main mechanism that is used. There are a few other sort of wrinkles to it, but in a nutshell, that's the mechanism from the regulations, and that is what gurgled back to life in 2016. Was Customs started issuing WROs, most of them targeting individual factories, most but not all.
Gotcha. So let's get into the guts of the WRO sausage making process. So how did this, I remember there was a lot of pressure from activists around in the early days when in say 2017, 2018, when it was the Trump administration was getting criticized for not necessarily being as aggressive as the law would potentially let them in enlisting more firms. So what's the sort of origin story of a WRO, and how has that changed over the past 5 years?
Yeah, so customs will consider allegations from basically all corners in deciding whether or not to issue a WRO. I think they've opened up a formal portal, quote unquote, an email address where allegations can be submitted. And customs will set, the regulations provide that a WRO may be issued upon evidence which reasonably but not conclusively indicates that some goods have been made with forced labor. So reasonably but not conclusively is a relatively low standard.
Let's stay on the standard for a second, John. How does this compare with export controls or sort of CFIUS findings or other things which can kind of get in the way of U.S.-China trade?
The reasonably but not conclusively standard for the issuance of a WRO is a very, very low bar. In theory, there is a lot of merchandise that comes into the United States that would be vulnerable to an accusation that it reasonably but not conclusively was made with forced labor. Customs would say that they have, in practice, tried to maintain a higher standard internally for the issuance of a WRO. But upon the issuance of a WRO, Customs does not provide any information about the evidence that it considered, the facts that it found, or anything about any determinations that were made regarding the existence of forced labor. Generally speaking, the most they've accompanied that type of determination with is a press release, which will, recite the varieties of labor violations or perhaps the varieties of indicators of forced labor that they found, but without providing any details or any sort of information. So, if you're an importer that is importing goods that end up being affected by a WRO, or certainly if you're a company that is named in the WRO, sort of understanding the basis upon which the allegations were made, that has been extremely difficult. And Customs has simply regarded it not as something that it is obligated to disclose to
Yeah.
any parties.
Yeah, you've seen the sort of evidence base is really tricky, and you've seen a number of firms sort of wave their hands and be like, "Hey, no, we're the good guys here. Like, you caught someone else. Please, like, reconsider this because this is like killing our business." And then silence out of the customs department. Though I think once or twice they've like ended up allowing firms to get off the blacklist, it seems.
Yeah, that's correct. So on very few occasions, they have rescinded WROs that were issued. Um, but those instances have been few and far between. And I guess this is as good a point as any to describe some of the evolution, which is
Sure.
that in the WROs, so the earliest WROs of this modern era, 2016, 2017, really targeted individual companies by name. But then beginning in 2017, 2018, Customs started to explore the possibility of identifying whole categories of merchandise, whole commodities, for example. And they did this in small steps first. So they targeted cotton and products containing cotton produced in Turkmenistan. And so this was a totally different variety of WRO, right? Rather than naming, XYZ factory in China, which is relatively easy to spot goods that come from that factory because that's actually part of every customs declaration. If you're an importer, you have to identify who the manufacturer was. So if you identify the manufacturer as XYZ company and it's named in the WRO, well, that's a slam dunk from a customs standpoint in terms of, well, this is the shipment I'm going to be detaining then. Cotton from Turkmenistan is a whole different animal, right? Because no one is declaring the origin of the cotton fiber of anything that's being imported into the United States. It's just not a requirement to trade. Nobody has to provide that information. So by imposing a WRO on cotton from Turkmenistan, in theory, any product that contains cotton from Turkmenistan would be subject to detention by CBP. But we don't know which shipments customs sort of thinks contain cotton from Turkmenistan, and therefore we don't know which shipments it was detaining, how it was going about that process. And that's where I would say the the use of the WRO mechanism started to fall apart a little bit because it was never designed to capture sort of whole categories of merchandise or whole, productions of production of a whole raw commodity that would exist deep in the supply chain. It just wasn't designed for that at all. And customs doesn't have the ability to identify where Turkmenistan cotton is. Therefore, it can't really effectively lawfully enforce the WRO under the law, under the regulations that create the WRO. And that was all sort of just an academic observation for a while. There were a couple similar types of WROs that were issued, but then we had the mega event of early 2021, right before the Trump administration left. They issued a WRO targeting a raw material, specifically cotton, produced in Xinjiang. So that happened to just be 17% of the global supply of cotton. Overnight, went from being perfectly admissible into the United States to subject to detention at the border. A fifth of the global supply of cotton. So customs doesn't know where that cotton is. A lot of importers had no idea where that cotton was or could have been in their supply chain. But customs took the view that we are authorized to issue this WRO. We've done it before. We've issued WROs against, categories of merchandise from entire countries or from entire regions. And why not? There's a lot of forced labor in Xinjiang. We've got concerns about cotton. It meets our relatively low standard. We're going to issue the WRO, and the WRO on cotton and products containing cotton from Xinjiang was born.
So what was the impact of the WRO on cotton, John?
Yeah, so I mean, it was certainly a massive disruption within global supply chains for companies that trade in goods that contain cotton, because any company that was importing a cotton made or a cotton containing good into the United States, whether that finished good came into, regardless of what jurisdiction it came in from, right? So cotton gets harvested in Xinjiang and then it gets spun into yarn, which gets woven into fabric, which then gets cut and sewn into various types of finished articles and imported into the United States. And all of those steps can happen in different jurisdictions. And in fact, modern global supply chains being what they are manufactured in all different jurisdictions. So Xinjiang origin cotton may be coming into the United States from every corner of the earth. And in fact, no doubt it is. What customs started doing was it began what it called, and to its credit, it took what it called a surgical type approach, a limited surgical approach. So it started by trying to figure out, and I think it was trying to assess where Xinjiang cotton may have been entering in the United States. But as a practical matter, they began by detaining shipments produced by Chinese manufacturers that contain cotton. There have been reports of some additional detentions targeting cotton-containing goods that were made in other countries, such as Vietnam. But again, customs has all of what we know about that has been sort of collected by rumor and anecdote, working in this space and within the industry. Customs does not disclose how it goes about deciding which shipments it thinks contain Xinjiang origin cotton, or what sort of factors go into the question of which shipments get detained and then kick off the, you know, flipped burden of proof obligation to disprove the presence of forced labor within a supply chain. So I think a lot of companies have had a real difficult time figuring out what to do in response to this. Because if customs were to stop a cotton containing shipment and say, hey, prove there's no Xinjiang origin cotton here, technically that's actually not a lawful use of the WRO mechanism. Customs cannot use a WRO to stop goods and figure out whether a shipment contains the merchandise that is referenced in the WRO. That's not a lawful use of a WRO. A WRO authorizes the detention of merchandise that is named in the WRO, which means customs has to know where the Xinjiang origin cotton is before it stops the merchandise. And if it doesn't, then arguably that's an unlawful detention, an unlawful use of the WRO. I think a lot of companies have tried to work with their suppliers to begin the process of tracing cotton through the supply chain, but it has put a huge premium on the ability, like the true ability to trace cotton through a supply chain. Traceability has went after the imposition of the Xinjiang Cotton WRO. It went from basically being something that was useful for supporting CSR or ESG type claims that a company might make to being really a necessity if you wanted to be in a position to have confidence that you could defeat a detention or stop a detention under the cotton WRO. You either could trace your cotton and the origin, the provenance of your cotton from harvest and the jurisdiction of harvest through to your finished goods and demonstrate to the satisfaction of customs that you can in fact trace the cotton at each individual step, such that by the time you have a finished good, you can demonstrate the origin of the cotton fiber, or you can't. And if you can't, you're subject to detention. You're subject to having to re-export the goods or possibly even surrender control of the goods at the border.
So longtime China Talk readers will know that about a year and a half ago, I wrote a piece sort of exploring the dynamics of enforcement around this. And the two things that I thought were really surprising, which was one, that the worst thing that could happen to you if customs detains one of your things is you just like lose your shipment of socks or whatever. There's no fine, there's no like longer outstanding penalty. And the amount of like the dollars and, full-time equivalents that end up supporting this forced labor division within customs was like shockingly small, like maybe like 8 or 10 folks. It seems like one of those two things, thanks to the UFLPA, is about to change.
Yeah, so a couple comments. One, I would say that the primary risk in a detention, in a WRO enforcement scenario is that your goods are subject to detention. Individual shipments are subject to detention. But individual detentions that cannot be resolved to the satisfaction of customs certainly raise the stakes with respect to other shipments. And it would not be hard for an individual WRO, an individual detained shipment under a WRO, to lead to a much greater supply chain disruption. And certainly an importer that continues to import goods that that are the same as goods that were detained and that could not be proven, Xinjiang cotton free, sufficient to obtain a release, would be running the risk of potentially civil enforcement in the form of fines or penalties.
That's encouraging. Yeah, because you basically the only stories you get are like, it was maybe a year ago now, like Uniqlo, like one shipment container was detained, and like one shipment container from Uniqlo is not going to have a big impact on their bottom line, but if it ends up being a sort of whole swath If that is just the tip of the iceberg, that makes a bit more sense.
Sure. And keep in mind that customs penalty actions are not public. So customs may very well have undertaken a number of penalty actions. We wouldn't know about that. And I think a lot of importers, if they were facing a penalty from customs on the basis of a forced labor violation, would be inclined to resolve that administratively before any suit was filed at the Court of International Trade. So I don't think that we would necessarily know if there were a lot of penalty actions being pursued, but there certainly is
Sure.
a potential basis for it. In terms of the funding has bumped for two different reasons. One, there was an earmark, an allocation of funding just to CBP's Office of Trade for purposes of forced labor enforcement of about $10 million for the current fiscal year, and then there was a separate allocation of money for enforcing the Uyghur Forced Labor Prevention Act, the UFLPA, and that allocation is $27.5 million to the Office of Trade just for the enforcement of the Uyghur Forced Labor Prevention Act. So that, I mean, sometimes it's hard to put numbers, government spending numbers into perspective because a few $1 million for an office here doesn't sound like that much compared to billions or trillions, um, obviously for other purposes, but it does put this issue far and away as the most important individually funded trade enforcement topic, I think, for the Office of Trade within customs. This amount of money is equivalent to about 2/3 of the entire budget of the Office of Foreign Asset Control, OFAC, which is the office at the Department of Treasury that is responsible for enforcing U.S. sanctions. So 2/3 of that entire budget for enforcing all U.S. sanctions programs at the Department of Treasury is going to customs just for the purpose of UFLPA enforcement, just for the Uyghur issue alone. So that doesn't include the cotton WRO, which is what we were mostly just focused on. It's entirely dedicated just to this issue of Uyghur forced labor enforcement. So huge bump in enforcement funding. I think we're going to see a lot of downstream results flowing from that.
So aside from having a lot of people to enforce this bill, what's actually in the bill?
So the Uyghur Forced Labor Prevention Act functions as sort of an add-on. You can think of it as like an add-on module to Section 307. And basically, what Congress did in the UFLPA is it said, okay, we recognize that one of the challenging parts of forced labor enforcement is deciding where exactly forced labor is happening, where exactly it's occurring. They said, we're going to make that easy for you. Okay, we're going to put our finger on the scale and just tell you that for purposes of U.S. law, we consider the human rights violations targeting Uyghurs and other ethnic minorities in Xinjiang and through the different social programs of concern out through, around China. We stipulate that all of this is forced labor for purposes of U.S. law. And so the Uyghur Forced Labor Prevention Act establishes a presumption that any good produced in Xinjiang or any good produced wholly or in part by an entity that comes to be listed under the law for the entity's participation in those social programs of concern, those goods are made with forced labor. And those goods will therefore be subject to detention under Section 307 under the forced labor import ban. So it was a really significant and very powerful determination. And in some respects, it was a determination that only Congress could make because the assessment of whether these particular social programs, constitutes forced labor. I mean, it is certainly a political variety of determination, which is to say, China views these programs very differently. It does not view this as forced labor at all. It views this as,
Sure.
social programs that have any number of different types of domestic defensibility to them. And the U.S., of course, has a clearly different view, views that this is unquestionably forced labor, and it being a political determination, therefore, where different countries have different views of the program. It was essential in some respects that the U.S. weigh in if it wanted to take seriously the issue of supply chain links to this issue.
So now, John, coming back to the the downstream impacts of this law, which is about to come into effect in mid-June. What are going to be some of the implications?
Yeah, so the Uyghur Forced Labor Prevention Act was enacted in December of 2021, and it had a 6-month lead time during which the U.S. government would be formulating a strategy to ensure the effective enforcement of this law. And so, pursuant to that strategy, there was a public hearing and there was a notice and comment period where comments were received. But the U.S. government will be producing a strategy for the enforcement of the Uyghur Forced Labor Prevention Act. That strategy is actually due to be published the same day that the enforcement itself goes live, that presumption of goods made in Xinjiang or made with by a listed entity takes effect, and that is June 21st. So between now we're recording this, I think it's just under 6 weeks before the date of launch. From here until launch, I would say what we are expecting is we are still expecting that strategy to be published. The strategy has a number of different elements and components to it, but it will be really, I think, a very significant document in terms of providing us guidance on how this law is going to be enforced. The strategy will also include lists of entities, and those are the lists that I referred to when I said the presumption applies to goods made in Xinjiang or by an entity on the list. The strategy actually includes those lists of Chinese entities that are identified as having some form of linkage to a social program of concern in China. So in that respect, the strategy document is not just a strategy document. It's actually like a legally binding, document in its own right, because the entities that come to be listed will be de facto, prohibited, de facto blacklisted from existing anywhere in a supply chain that is destined for the United States.
Um, so John, what are some of the other implications of how this is all going to play out?
Look, I think that it's going to be very interesting to see how many entities end up getting listed under the UFLPA, and I think that that's really going to determine, in a significant extent, the impact of the UFLPA in terms of how far-reaching it is and how consequential it is. One would think that with a funding level like what has been allocated, the expectations of Congress are that this is going to be a very significant disruption in the context of U.S.-China trade. That listing process of identifying Chinese entities that are linked to the social programs of concern has the potential to be almost a whole other front in the whole U.S.-China trade relationship, or I could say conflict. When Trump administered the Section 301 tariffs and imposed 25% tariffs on $50 billion worth of goods, that was an overnight sensation, and everybody was aware of the impact of this action, and particularly as it progressed into additional lists and additional impositions of tariffs. This is a little bit more of a sleeper in that we don't know exactly the full extent. We don't know how many entities are going to be listed, and we don't know what the full extent is going to be. But I would say that there are certainly hundreds and probably thousands of Chinese entities that are potentially linkable to one of the social programs of concern and would fit within the categories of the UFLPA, such that those entities could end up being listed. And so it's going to be very interesting to see how many companies end up getting listed and exactly how dramatic that is. But if you think of a supply chain as sort of a network or like a family tree, right, running backwards, where at each sequential step going further back, you have more and more entities involved at that same generation. So every importing company with a supply chain that runs through China has some sort of, Chinese family tree there of suppliers. The listing process has the effect of blacking out and making it illegal for any individual listed Chinese entity to continue to remain a part of that family tree supply chain towards the United States. If a lot of different Chinese entities end up getting listed, or if significant players, significant suppliers end up getting listed, you're going to see massive, potentially massive disruptions into U.S. bound supply. And especially if the administration ends up listing, really significant materials providers or suppliers that are deeper in the supply chain. The larger an entity is and the deeper in the supply chain it is, the more consequential the listing becomes, because you can think of all of the different downstream channels that flow from a really major, tier 3, tier 4 material supplier in China. Every one of those supply lines is thereafter prohibited from entering. Those goods are prohibited from entering the country, and any company that does not act to stop that is leaving themselves vulnerable to pretty significant enforcement in a scenario where the U.S. has already found the existence of forced labor. So I think that's what I'm really watching is how many entities are listed, how significant the listings are, and I think that that's what most companies need to be focused on first and foremost.
So, this isn't just cotton, right? There's been a lot of talk around Xinjiang and solar, and my expectation is that there are other sort of like weird third and fourth tier things that Xinjiang makes, which will be kind of uncovered, and I imagine that industries that aren't necessarily super on top of all of this are gonna likely be surprised at these interconnections when you start talking about these families in
Yeah,
particular.
no, I think your question is exactly on point. The answer, this is not about cotton anymore. I would say absolutely. This action, UFLPA, is not cotton specific or cotton focused. The cotton enforcement that is currently happening because of the WRO on cotton originating in Xinjiang, that is completely independent of the UFLPA. It predated the UFLPA, and it will continue to exist and run on its own course. There is not a direct connection between the cotton and the UFLPA enforcement, other than the fact that the UFLPA does call out a couple of specific commodities and industries, and specifically requires the US government to identify other high priority items that are produced within the region, and then seeks to identify Chinese companies that are linked to those products. I could not begin to opine on what
Yeah.
additional subject, individual products are going to be hit, or other industries are going to be hit. But we do know that the social programs involving particularly labor transfer of Uyghur workers throughout China, I mean, this is a regular feature of the domestic labor economy. Domestic migrant workers is a huge feature of the Chinese labor market in general, and any state-sponsored movement of a batch of Uyghur workers pursuant to a poverty alleviation initiative would presumptively be a basis for listing, and a basis
Yep.
upon which an entity could no longer exist in a US bound supply chain. So it's going to be very interesting to see how other industries react and respond as the enforcement builds.
Having spent a few dozen hours trying to play the "Oh, what industry is potentially next" game, my conclusion was that you actually do need millions of dollars to answer that question, and but millions of dollars can answer that question, and no one spent that money yet, but it looks like customs is about to. John, there's been a bit of political kerfuffle, or at least Senator Rubio speaking out about he in particular is worried that the Biden administration may not be quite as aggressive as some would hope on using the sort of powers and money allocated to do rigorous enforcement. How much wiggle room does the executive branch have in how they're going to play all this out? And what do you think are the dynamics potentially impacting how the Biden administration is going to use this bill coming online?
That's a great question. I would say that I think that the WRO example is maybe a good comparison point. So if you think back to just the Section 307 and how that is enforced, the forced labor import ban, and how that is enforced with WROs, there have only been a few dozen WROs that have been issued in this modern era of forced labor enforcement. And what's interesting is that there's not a ton of overlap between the products, the commodities that have been targeted by CBP, and the lists that are produced by the U.S. government on an annual basis of goods known to be produced with forced labor. So the Department of Labor, the Bureau of International Labor Affairs, ILAB, produces a list every year of goods that are known to the U.S. government to be made with forced and child labor. If you look at the forced labor portion of that list that ILAB produces and the WROs, there are many, many fewer WROs that have been issued than against the full scope and scale of products that are known to the U.S. government as having been made with forced labor. What conclusion I draw from that is that there is clearly discretion on the part of customs when it comes to the issuance of withhold release orders. And that's a relatively low threshold, right? Reasonably, but not conclusively establishes that product X from country Y is made with forced labor. They can issue a WRO. Obviously, they are not doing that in every instance. I don't know what all factors go in. I'm just not privy to the decision-making process, and none of it is public. So none of us have any idea what goes into the decision-making process. I would say we are at a similar lack of information, notwithstanding the efforts to sort of do public engagement. We don't know, following the public hearing and following the notice and comment period, we do not have any idea what sort of process is going to be created around the listing mechanism under the UFLPA. We do know that the statute requires that the group that is responsible for preparing those lists, that it is required to cooperate with non-governmental organizations, NGOs, and in terms of considering allegations and then undertaking the listing process. That is really significant to me because NGOs and researchers, academic researchers, have shown both the ambition and the ability to undertake research of Chinese entities and produce information that would link an entity to one of the social programs of concern. And there have been a number of reports that have been issued, and every time another report is issued, it comes with sort of dramatic effect. Tons of press, will pick it up. A lot of that reporting was, in fact, deeply influential, even in the creation of the Uyghur Forced Labor Prevention Act in the first place. And so what the UFLPA basically does is it creates sort of a government window where allegations like that are going to be able to be filed, and the task force is going to take it up. There certainly is a space for this task force to exercise discretion. I don't know what they're going to do. I don't know what to make of the sort of repeated, ongoing, expressed concerns that the administration is not taking this seriously. I just can't say, but I will say that there is scope for the exercise of discretion, and it'll be interesting to see.
Yeah. No, it's been sort of watching it have to fall to sort of NGOs and academics that seem to start the ball rolling, and you see a number of WROs where it's kind of clear that they're actually taking that sort of they're following the lead of these outside researchers, potentially because of resource constraints. Maybe that's public pressure to do something once you have this big stories and reporting around allegations of forced labor. But now there's not going to be that excuse of like of this effort not being properly resourced.
There's no question about the closeness of that relationship that you described. The Commissioner of Customs actually testified before Congress that non-governmental organizations are in his words, the eyes and ears of CBP when it comes to forced labor allegations.
Which is wild. That's a wild thing to say.
I thought it was a wild thing to say. I agree with that. But so there's no question about the affinity and the partnership that exists there. And I think what makes it particularly wild is the fact that it's not a process that has any transparency to it, right? We don't know the types of allegations that are filed unless a private third-party entity that filed an allegation wants to go ahead and make that public. We don't know what the deliberative process is like. We don't know what the decision-making process is like. We don't know what factors are considered significant or insignificant. We don't know whether there are any sorts of policies around not, imposing WROs in certain instances or what would tip the needle in other instances. And my concern is that the listing process under the UFLPA could very similarly be marked by a similar degree of opacity. Hopefully not. Hopefully there will be a transparent process whereby it will be evident what allegations have been made, what sort of factors have been deemed significant, and the basis upon which these determinations are being made, as well as ideally an opportunity for those decisions to be reviewed. Look, this whole apparatus, it either is subject to the rule of law or it is not. And if it is not, then it is subject to the rule of accusation and insinuation. And that's just not really any way to run an effective form of trade regulation. Yeah, the issues are very serious. The allegations are incredibly serious and deeply concerning. And the situation, I think, is certainly serious enough to warrant taking the allegations seriously and being willing to be, subordinated to the facts as they are demonstrable. Any desire to sort of push forward with the enforcement process without that sort of transparency and willingness to lay out the basis of determinations, um, I think it does not bode well for the continued sort of rules-based trading system that we have grown accustomed to.
Comparing the sort of, because obviously there's going to be sources and methods, there'll be some secret stuff that goes on, and not, you can't be, there are limits to what you can expect, but maybe comparing sort of what level of transparency you get with these OFAC sanctions designations. What has Treasury shown it's been able to do in that regard?
I'm gonna have to punt a little bit on that because it's outside the scope of my primary practice area. But I would say that at a minimum, what could be created would be a mechanism whereby there's at least a notice of proposed determination and an opportunity to consider contrary information. And then once a decision has been made, some sort of mechanism for reviewing the determination subsequently, deciding whether the facts, continue to warrant the imposition of the consequence, whether it's listing or the imposition or issuance of a WRO. Those seem to me to be very low stakes kinds of protections that could be put in place. In other words, we're proposing to take this action, we're proposing to list this entity, we're willing to consider alternative points of view, and then a mechanism for review and sort of continuing to clean up. And I would just comment that there is no mechanism for ongoing sort of upkeep of the existence of WROs that have been issued under Section 307. The oldest WRO was issued in the 1950s, and it's still in effect. It applies to furniture that is made by a particular penitentiary in Mexico. Who knows whether this this penitentiary even exists anymore? But there's no mechanism for sort of going through, even doing routine maintenance and cleanup of the list, let alone some sort of systematic review and sunsetting or anything of that nature. So these are what I consider sort of very basic rule of law type protections that if you're going to have look, if forced labor enforcement is just a sleepy corner of the law where 15 WROs are issued against 15 individual tiny, XYZ corporation mom and pop companies in China and a few others in Latin America or something, like I guess it doesn't matter all that much whether you've got really good rigorous protections and controls in place. If it's going to be funded to the scale and scope of all U.S. sanctions enforcement or a significant percentage of all U.S. sanctions enforcement, if there really are going to be hundreds or thousands of Chinese entities listed, like it needs to have some basic sort of due process type rule of law protections that are built in and baked in. And the law did not design that. The law sort of gives space to the Forced Labor Enforcement Task Force as the arm of the U.S. government responsible for developing the strategy and designing and implementing the enforcement. It really is up to that task force to decide whether or not to create those types of mechanisms. And it'll be very interesting to see whether they're responsive to those types of asks.
John, talking about the sort of dynamics of firms pushing, trying to push back and get themselves back in the good graces of of customs. Obviously a problem is that A, you can't really go to China nowadays, and B, even if you could, inspecting Xinjiang adjacent supply chains is not something that the Chinese government is particularly excited to let supply chain verifiers do. So what is the kind of playbook for firms nowadays to make the case that that they're not like the other guy?
That is a great and extremely difficult question, and I think that what would be very helpful to see, and before you can sort of opine on that, is what sort of mechanisms are created, particularly for the review and reconsideration or revisiting of a listing determination. I do think that under any scenario, it is going to be exponentially easier to list than it is to delist. And I think for that reason that it is very likely going to be the case that the listing mechanism becomes the most influential and far-reaching portion of the UFLPA legacy. It is definitely possible that that list could simply grow and grow. And you're right. I don't think that there is an obvious set of factual information that could be submitted that would necessarily result in a delisting after the listing has happened.
Regardless of the sort of nitty-gritty on this, watching the US government take a more serious approach to forced labor is, I think, something to be applauded. And there most surely will be growing pains as a field of regulation, which like kind of didn't really exist even before 5 years ago, all of a sudden is in its sort of like birth pangs. So
I just wanted to invite any of your listeners that might be interested in this topic. I do send out a newsletter on the state of play of CBP's enforcement of the forced labor import ban. So, to the extent that anyone is interested in receiving updates on how that is evolving, they should feel free to reach out to me. I'm on LinkedIn, John Foote, Foote, and I'd be happy to add them to the distribution. As this is the only law globally that is being currently enforced as a cross-border restriction on goods produced with forced labor. I think that what customs does and doesn't do is really interesting and highly instructive. So, to the extent any of your audience feels the same way, they should feel free to reach out. Be happy to add them to the newsletter.
So, John, looking forward to staying in touch and keeping following how this space evolves.
Thank you for having me. Always great to speak with you, George.
Aziz başım niyad eyle Ela Nurhan mazaler geçirah yaksın Allah vay ele Nurhan Ayre şeriyenge musafir men Bundak mı bular men Ayre bundak mı bular men Ayre bundak mı bular men Elenur halk küydüm men Ayre bolalerge kalar men Allah vay Elenur han Ayre şeriyenge musafir men Ayrılğanğa ölmeymen eşelerim yaman Aqidem gizglaymen Yar barçaqdı yaxşıdık ey yar ketib yaman boldu Yar barçaqdı yaxşıdık ey yar ketib yaman boldu yar derdini köp tattım. Ayrılğanğa ölmeymen ey derdiniz yaman. Aqidem gizirlaymen. Ayrılğanğa ölmeymen ey derdiniz yaman. Aqidem gizirlaymen.